Peacock. Nick is an English law qualified dispute resolution lawyer who acts and advises on large and complex commercial disputes, usually with a cross-border element. He is a partner at Herbert Smith Freehills. The panelists include Mr. Bobby Chandhoke, senior partner at L&L Partners Law Offices. Bobby has over 25 years of experience in handling both ad hoc and institutional commercial arbitrations. We also have Mr. Naresh Thacker, who heads the litigation and arbitration practice of ELP. He's also qualified as a solicitor in England and Wales, having over 20 years' experience in litigation and international arbitration. He's currently a member of Mcia. Our third panelist is Ms. Poornima Hatti, partner Samvad Partners. She heads the dispute resolution practice at Samvad and specializes in corporate and commercial disputes, including construction and infrastructure disputes, shareholder disputes, and insolvency matters. She also sits as an arbitrator and mediator in both domestic and international arbitrations and mediations. We have Mr. Rajbeer Sachdeva, President, Group Legal JK Organization, who has over about 29 years of experience as a corporate lawyer. He has extensively worked in domains of mergers and acquisitions, competition laws, real estate transactions, and arbitrations in India and abroad. Rajbeer was previously Senior Executive Director, Group General Counsel at DLF Limited. Our last panelist would be Shuva Mandal, Group General Tata Sons Limited. Shuva is the Group General Counsel of Tata Sons, the holding company of Indian conglomerate Tata Group. Previously, he was at Shardul Amarchand Mangaldas as a partner and National Practice Head for Corporate Mergers and Acquisitions and Private Equity till 2017. May I please request the moderator to begin the session, please?
Thank you very much. Welcome to the last panel session of the afternoon before we get to the grand debate. We, however, will try and keep or start early by generating the debate on a very important topic, that of the timeline of dispute resolution. Which topic can be more important? There is simply no point in having a dispute resolution process for commercial disputes that does not get you an answer within a commercially sensible time frame. Because if it's going to take you an inordinate amount of time to get to the end, then commercial organizations are not interested. It doesn't help them one bit. So one of the great topics of the recent amendments has been how it's dealt with the timelines that were introduced in the 2015 amendments under 29A and builds on an attempt to attack the problem of delays in commercial arbitration that was prevalent in this jurisdiction, and not in this jurisdiction alone, I should say. This is not a uniquely Indian problem of how to get efficient and speedy dispute resolution through arbitration. But India has taken a particular approach to it. We're going to ask ourselves whether that is a good and effective approach, where it leaves us now. And we'll also have a think about what other levers can be pressed, what other approaches have been taken by other jurisdictions and by arbitral institutions. But I want to try and take this topic in a number of stages. Firstly, to look at the essential problem of delay in arbitration and to ask ourselves what the particular problem is that India has experienced with delays in arbitration. Then I want to look at the situation as it was developed under the 2015 amendments. What was done there? What was the outcome of that? And how did that then get us to the 2019 amendments? And whether those amendments, and that's the meat of this discussion, are really helping us by reversing the strict timelines, or in fact just by adjusting them. Well, query, we'll come at the drafting as well and see whether we think it works. So let's take first a bit of context. I'm going to ask Naresh just to give us all a bit of background about what is the problem of delays as someone who's operated in this jurisdiction for many, many years and has seen arbitration under the 96 Act before 2015 in the gap between the amendments and now looking forward now. Naresh, what do you think the problem? What was the problem with onshore arbitration in India, which the strict timelines sought to correct?
Many thanks, Nick. So, let me start by saying that I think there was a session in the afternoon just before lunch where Dr. Birendra Saraf spoke about this being a problem of mindset, and I think, to my mind, that is exactly what it is. It's nothing to do with law. The law, you can make the law as best as you could, but ultimately, if your mindset does not change, and the mindset, and when we talk about the mindset, we are talking about the mindset both of all the stakeholders, whether counsel for the respondent, counsel for the claimant, the parties themselves, and it's very important to bear in mind that the parties have the largest stake in the entire process. So it's the parties whose stake is all the more the skin is the parties, and that is in the game. And obviously, it also is quite same for the lawyers as well as for the arbitrators. Now, prior to 2015, well, the problem that one would face is that arbitrators would not give you time. There were very few arbitrators. Those arbitrators were much in demand. And yes, they were retired judges by and large. They had their diaries full. It was very difficult to get time out of their diaries. It was also actually very difficult to get time out of a lawyer's diary for him to come and argue a matter on a sustained basis from Monday until Friday. The lawyer would agree to do it, but provided it was kept in the evening, which worked very well for the arbitrators as well, because they would work in a very short session, but at the same time charge the sort of fee that they would want to charge. And Saturdays, Sundays is something that people used to take as arbitration days, really, and that used to be the manner in which arbitrations were run pre-2015. Come 2015, we had the change in law, and with the change in law, there was a change in the mindset. To my mind, it is not as if that the implementation of the law brought about that bigger change in the sense of the time being implemented in the manner that one would want it to be implemented by the arbitrators of their own volition. They did it because the fear was that, if the matter landed up in court, none of the arbitrators wanted their name up there. They did not actually want their names to go into the court at all in the first instance. Therefore, they started forcing parties to agree to a 6-month extension immediately as the arbitration would begin. So in the very first procedural order, the question that an arbitrator would look at both the parties and ask is, are you willing to enter into an agreement right away to say that there is an extension by 6 months? So the 6-month extension, which actually should have come at the end of possibly the 12-month period, was pre-decided in the very first procedural order. Again, to my mind, yes, not all arbitrations are the same. So you can't have one size which fits all. So 12-month period may not be the right period. And to my mind, for a large arbitration, it never was the right time frame. But then there was an 18-month time frame which was available. You look at the international average, talk to ICC, talk to LCIA, SIAC, and they'll tell you that 18 to 24 months is really the time frame for a large arbitration also to get over. So to my mind, it was a good enough time frame for an arbitration. Beyond that, you did have the liberty of approaching the courts and seeking that extension from the courts. What happened post-2015 was that the mindset did change, and we saw that the arbitrations which otherwise ran from 5 years to, let's say, 10 years. I have personally done a matter which ran for 10 years. And at the end of 10 years, the parties had lost interest. And thereafter, there was also the issue of enforcement hanging fire. So no one really wanted to do the arbitration or go the arbitration route at that point in time. Things changed. Yes, it came down substantially. The time frame was reduced to roughly 24 months to maybe 28 months, which in itself was a welcome change. Again, now we have another change which is being brought about by the law. Good or bad is for people to see. If you ask me, I do believe that it's a regressive step. We are talking about, arbitrations in India galloping ahead. To my mind, it's a regressive step for the simple reason that once again you've taken away the whip that was available, for the purposes of hastening the entire process, rather than that, what you've done is you've taken away that whip and you have left the arbitration or brought the arbitration back to what it always used to be.
Thanks, Naresh. So, look, I think an important word there was mindset. Certainly the attitude of all stakeholders to this process is critical. Now, obviously, once a dispute starts, there will often be one party that has got no real commercial interest in pushing the resolution of that dispute along. But still, all stakeholders who want to use arbitration as a process must recognize that overall, they have an interest in making it work efficiently. And even those of us who are servants in this process, it's in our interests to make it attractive and to make it work for the commercial users. Now we've looked at mindset. I think it's also probably fair to say there are structural issues. I mean, we've been talking about the issues of delay in Indian arbitration for many, many years. And it's quite a complex question because in part it relates to the structure, the way arbitrators are appointed, the way retired judges took their appointments, the way that hearings had to be run after court hours because arbitration counsel are also litigation counsel. So there are structural things there, I think. And I'd like to turn to Poornima and just think about what institutions can and have done to try and attack the problem of delays in arbitration. Obviously, India remains a market dominated by ad hoc arbitration. But in the last 3 years, wonderful institutions have been brought to life through the sweat and tears of busy individuals. And we now have institutional arbitration that we can push with full confidence in India. So, Poornima, what's your view of what the approach taken by institutions and what structural mechanisms can be used to push arbitration along, aside from the statutory time limits we're dealing with here? What other levers are there for us, do you think?
Thank you, Nick. I just want to refer to Justice Indu Malhotra's remarks this morning when she referred to the ease of doing business and the ease of enforcing contracts and the aspirations of the Indian government to sort of really skyrocket from our current position to, I think she said, rank 30 by 2020. I'm not sure we'll get there. But the idea of actually speed is one of the points that we're often asked by international clients, and how fast can you enforce the contract? And most of them actually have an arbitration clause. So, and if you look at the Justice Sri Krishna Committee report, it talks about pushing institutional arbitration in India, and one of the reasons to do so is to improve efficiency both in time and cost. So we're looking at the amendments from that lens. If you open the MCIA website and sort of go to the rules, the sort of introduction to the rules really address, in my opinion, the issue of delay more than anything else. You'll first see that they offer expedited procedure. You'll talk about emergency arbitrators. You also see that consolidation is now something that's reflected with the MCIA rules. So this is not just with the MCIA. These are aspects that are reflected in almost every international arbitral institution. So the arbitration institution community is conscious of the fact that there has to be some sort of framework, even without looking to the statutory framework that exists. And if you look at the sort of timeline from 2016 onwards, the ICC and the LCIA, as well as the SIAC, have sort of responded to business needs. So it'll be interesting to sort of hear the perspective from the users of arbitration on this panel from that perspective. the fact that, there could be costs imposed on the arbitral tribunal for delay in sort of getting to an award, or even the scrutiny process at the ICC, if it takes much more than 6 months, there is an impact on the arbitration itself. So these are self-imposed sort of guidelines to make sure that the arbitration is pressed along and is concluded within a certain time frame. And as Naresh said, the framework really is 18 to 24 months, as has been proven through statistics across international arbitration institutes. So yes, I think there's enough within these institutional frameworks to press on. Of course, one should look at the use of technology. The Sri Krishna Committee report also said that they want to push technology in terms of e-discovery, e-filings. We're yet to see that adopted even in institutional arbitrations widely within India. So that's something that one has to look, again, from the lens of time. And hopefully that could be used within the rules as well. Thank you.
Thank you, Poornima. Let me just stop here and ask Shuva a question. Shuva, you have responsibility for a vast number of businesses who use all sorts of dispute resolution. What is the right length of time for dispute resolution? We've heard 18 to 24 months. We're looking in some of the rules about 6 months from here. We're looking at 12 months from there. We've got 18, 24 and longer. How long do you want to wait before your commercial disputes are resolved? What's the magic time period for you?
Nick, Nick, there is no right time.
Yeah.
Let me tell you this. It depends which side of the table you're sitting. So here's the challenge, and I've been quietly absorbing a lot of conversations here, thoughts here. The core question being timing, delay, why all this? I mean, let's scratch a little bit, let's go a little deep. Why is this happening? It's about behavior. It's about incentive. So I'll just make it statistically interesting for you here. So why should anybody be quick in an arbitration? Let me ask the counterfactual. Why should it be? How does it help anybody? It doesn't help the government of India for sure. It doesn't help National Highway Authority for sure, the largest counterpart, correct me if I'm wrong, in arbitration in India. Why? Because there is no arbitrator in India who will impose 18% interest. So today, for an average corporate in India, the cost of borrowing capital is 12 to 14%. The interest tribunal will impose is in the range of 9 to 10%. Correct me? Yeah. So tell me, why should I settle? Why should I expedite? I'm getting a free service from the judicial system in India. Be it courts, be it arbitrators, call it what you want. It's a fantastic opportunity to make money.
And what if you're chasing them? What if you're the claim?
So we need to talk the real stuff here. The real stuff is, if you want to get speed into arbitrations, let's talk. Why does my friends in Clifford Chance, when you ask them about their clients, they would breathe heavy, they would think 3 times before they press the litigation button, be it an arbitral, be it a suit. Because if they get it wrong, they're going to be imposed with heavy costs. Same with you. In India, nobody thinks about costs. I mean, what is it? I mean, you hired the most star-studded litigation panel. It's going to cost you $6-7 million. You're fighting a $200 million claim. Just do the maths. You've got a 4% interest arbitrage in delay. So I think we've got to get the incentives right here. So I think everybody gets what I'm saying here, be it litigation in the courts, be it arbitration. Unless we move to a culture of heavy imposition of interest rates, heavy imposition of costs, there is never going to be a speed up. All these 6 months, 12 months, 18 months here and there, it's all, I mean, we're just playing around.
Okay, thank you.
Sorry, Nick, can I add?
Yes, please.
Can I add to what Shuva said? And I can feel Shuva's pain. He is largely the claimant and very rarely the respondent. So therefore, I can understand where he's coming from. We all talk about the reversal in the time limit and, question whether it is regressive or not. There are opinions saying that, well, you don't really need the time limit. Why should you have time limit? It impinges upon party autonomy and the like. We can all talk about this at all points in time. If actually people miss the point, it is this introduction of time limit is not a new thing, at least in the Indian context. You look at the 1940 Act. The 1940 Act itself, Schedule 1, Rule 3, had a time limit set. So it's not a new thing. The 176th Law Commission report, which was just 5 years, 6 years after the 1996 Act coming into the picture, had a similar amendment where a 29A was to be brought in and there was a time limit to be set. So this is nothing new. And why do we have, therefore, where is the mindset of the legislature coming from when they want to impose a time limit? You are looking at the culture. You are looking at culture of delay and you are seeking to address that. If you are seeking to address the culture of delay, and as Shuva said, unless, our courts start waking up and start talking about heavy costs, things may not change. My sense is that if you had something in there which was possibly working or which had started working, 3 years that we've seen with the change in law, things had started moving. It is not as if that things have not moved. You heard Dr. Birendra Saraf in the afternoon say that the time limit has actually come down by 2.5 years or 3 years. It's a good thing. It's a good thing. Why want to tinker with it?
Yeah, but sorry, I also have a slightly different view on this. When you ask me a question, what is the right time? And I said, no, there's no right time. Let me tell you, arbitration, I think there's a mindset issue here also. We tend to take it as an adversarial process. It's not. I mean, an arbitration inherently is a resolution. It's a settlement. There's a reason why we use these words very differently from a litigation system. And I think that needs to be understood amongst the parties. So I'll give you an example. You're putting a clock on the arbitration. You're putting a clock. Sometimes it is the best thing not to have a clock because very often arbitration is a path to a settlement. My experience, I've rarely ended up with an arbitral award. We've always cut the cake somewhere in the middle. And when you put these clocks, you're disincentivizing parties to actually settle, to resolve. So I think there's a lot of merit in not having a clock. And if two parties decide to sit on the table and say, we're going to take 9 months just to talk amongst each other, so be it. It's a private forum. Why is the rest of the world getting excited about that?
Okay, so should we have a clock at all? And I want to turn to Bobby here because we were discussing earlier on that India is not unique in thinking that actually a clock in the statute might be a good idea. Bobby, I think you've been thinking about some other jurisdictions.
Yeah, so first of all, can I just make some comments on what's already been said?
Of course.
So I think there is a discussion about, the ICC and the SIAC completing their awards between 18 to 24 months. Absolutely correct. And I think Poornima talked about the use of technology. Now, I want to just make one point. This 18 to 24 months there is possible only because live transcriptions are used for cross-examinations. And I think a lot of time in our Indian arbitration goes by in very lengthy cross-examinations, which the arbitral tribunal is very lax to actually curtail, lest it be accused of not following the due process. Now, if you did and somebody was talking to me about how expensive it is to have transcription services. Now, if I look at the expense part, and if I compare what a senior counsel charges for one arbitration sitting, and what would be able to be achieved in 3 days of transcription, which is about 5 witnesses covered in 3 days, I'm saying that you would save, a huge amount of money, let me tell you this. It's a huge amount of money. So somewhere along the line, I think we need to bring in those transcription services into India, to bring them there. Timelines, I'm sure that even the timelines which have been extended here for some time can be constricted. I have some views about those extension of timelines as well, whether they've been actually extended by how much, et cetera, et cetera. I'll come to that. The second aspect was whether India is the only place where you have, this kind of a clause which restricts the time limit. And I think Nick can also add to this because I think he's done some kind of work. I just did a preliminary work on certain jurisdictions, and I found that, yes, there are several other countries which do have a mandate of closure. Honestly speaking, most of them, the timelines are about 6 odd months. Or so, 6 to 9 months, maximum 12 months, that's about it. Then, of course, you have to go to the court for extension, etc. But one of the factors that I found, and at least most of those jurisdictions, and I'm sure Nick has some examples of of countries which do not have that, is that they are preceded by these words. This says, unless otherwise agreed between the parties. So what happens is that you give party autonomy the first say, and then you come to the statutory limit. Unfortunately, in India, we have not followed the party autonomy route insofar as this is concerned, and Naresh is absolutely correct. I think he and I have both suffered 10 years of arbitration under the old regime. And honestly speaking, when this thing came in, it was not as much as, the constriction that we put upon our timelines, but it was a knee-jerk reaction to a system that was in place which was just not adhering to timelines. Now, thanks to this, we could have, or we are moving towards having a arbitration which actually commences at 10 o'clock in the morning and finishes at 5 in the evening. We can actually have a Monday to Friday, and probably, I think the arbitrators as well as the lawyers need some rest on Saturdays and Sundays, and probably at least on Sundays. So at least Sundays can certainly be off. So, and I've always believed that, work expands to meet the time allocated. You allocate 12 months, your arbitration will finish in 12 months. You allocate 36 months, your arbitration will finish in 36 months. The process is that, I think right from day one, when the first procedural order is passed, your timelines are set in reverse. So the arbitrator considers that he will take 2 months to pass the award, goes back to when he should hear the final arguments, goes back to when he should have the evidence, and goes back to when he should have the pleadings and discoveries, etc., etc. So all of this is being done in reverse. It's a reverse process. So whether the time period is 18 to 24 months, it's 12 to 18 months, that reverse process will always happen. And there is actually a charge up to be able to achieve that objective. I think those are some views, and of course I'll revert to some of the actual statutory amendments and how they are a boon for lawyers to be able to just interpret and keep on interpreting. And we'll probably call upon the House also to give their comments on how these are to be interpreted.
We're getting to the amendments, but I do want, and I'm enjoying, I hope you are too, this discussion of the fundamental problem and the different levers we have. And as Bobby said, I had a little look. Now, in my home jurisdiction, London, we don't have a timeline for the end of the arbitration. There's no fixed statutory period, nor in Singapore where I used to act. But I did a little bit of digging and found quite a few jurisdictions that did have some kind of time frame. Brazil, not many of you have arbitrated in Brazil probably. Final award is to be issued within 6 months of the appointment. France, I thought quite interesting. So Paris, as an arbitral seat, the Book 4 of the Code of Civil Procedure says that for domestic arbitration, the tribunal's mandate is limited to 6 months from the date on which the tribunal is seized. Now, Indonesia, a jurisdiction I used to do an awful lot of work in when I was based in Singapore, there they have timelines. The hearing of the dispute must be completed within 180 days from the formulation of the tribunal. The award must be rendered not later than 30 days after the conclusion of the hearing. Luxembourg, not a great or popular arbitral seat, has a timeline of only 3 months for the arbitration to take place, albeit the parties can extend that. And the UAE also has a time limit. Subject to agreement by the parties, the tribunal must issue the award within 6 months from the date of the first hearing. So this statutory approach is not unique to India. It's a lever that's been tried elsewhere, including in France, which I think we'd have to accept is a pretty popular arbitral jurisdiction for its domestic arbitration. So again, let's think about whether we need it or whether we need it along with other things. I want to now come to Rajbeer and ask his experience of delays in arbitration. Rajbeer, we talked about the sort of historic problem, and you've been an in-house counsel for a long time, and you've seen arbitration under the old regime and under the 2015 regime. What's been your experience of the difficulties of getting your disputes through in a timely manner, and the problem that delays have had, and whether the 2015 amendments in particular, did they make any difference, putting in these strict timelines?
Thanks, Nick. In my view, time limit is quite important for any arbitration or for any litigation. And it is not something unique to India. In other countries also, as Bobby said, unless parties otherwise agree, while party autonomy is important, but at the same time, time limit is quite important for the parties. In a time-bound manner, the arbitration should get concluded. Again, it's a mindset or a culture which we need to imbibe, and we should have some kind of a discipline within which those arbitration proceedings should get concluded. While delay needs to be addressed, but I think we also have to see one aspect: the delay should be seen in the context of whether it is practical. Now, there are complex arbitrations where, let's see the amendment. The proposed amendment of 2019 proposes two timelines. One is the filing of the statement of claim and defense, which is to be completed within 6 months. And thereafter, within 12 months, arbitration has to be concluded. Now, there could be a situation in a particular arbitration matter, if it's a complex case, the 6 months period may not be workable. Now, what happens if the parties are not able to file those proceedings or those pleadings, and they are not able to file the statement of claim or defense within the 6 months? What will be the fate of this arbitration? Whether it will continue or it can be extended, that 12 months period will be added to that 6 months, there is no clarity. Now, there could be a situation where earlier, before this amendment, at least there used to be a procedural order which arbitrator used to pass, setting the timelines within which the parties were supposed to file their pleadings, and then the arbitration proceedings were to commence. With this 6 months, I think it is becoming a stringent timeline in certain cases. It may open up another set of litigations where parties will say, look, we have not been able to complete our pleadings within 6 months, and they'll approach the court and may ask for an extension of time. Second issue which is coming up is the extension of time, which is envisaged under 29A. They have added a proviso by amending this where application is to be made, and pending that application, the mandate of arbitrator will continue till disposal of the application. Now, what will be the impact? How this will be interpreted? What if arbitrator takes a decision while pending the pendency of this application before the court? If the arbitrator passes an award, whether that award will be nullity, again a question to be seen, because technically there's an extension of time which is being sought from the court, but so far the court has not decided, and I have a personal experience where the arbitration proceedings were over. The matter was, the pleadings were completed, arbitration proceedings were over, the arbitral tribunal kept the matter for final award, and he took 6 months, and by the time the time limit had gone of 18 months, arbitral tribunal then wrote to the parties, please file an application seeking an extension under 29A. Court took 1 year to dispose of that application. So these are the practical difficulties, and I tend to say somewhere time limit is something which has to be a sacrosanct. And that is my take. Unless you keep a discipline of those timelines, this will never get concluded.
Thank you, Rajbeer. So I want to turn on to the 2019 timelines, and I'm going to go to the panel in a minute. But firstly, I want to go out to the room, because I'd like to know what the experience in the room was, or is, because it'll still be going on, about the 2015 amendments. So once these strict timelines came in, and there was a great deal of apprehension that we can't get arbitrations through in 12 months, in 18 months, the courts will delay making hearing applications under 29A. And yet when I've been coming back to this forum for the last couple of years, I've heard that it was sort of working. It seemed to me that it was sort of working. I know there are certainly criticisms of it, and I'd like to hear any experiences in the room as to whether you think that the system was working, not because I think we should rail against the 2019 amendments, although we'll come on to them now, but because I think it would be interesting to know whether the sea change of having any timelines in this Arbitration Act really brought about a change in mindset, which I think Naresh has suggested it did, and whether that was the start of reforming delays in this system. Because I think we also heard today from Justice Malhotra that there was no real attempt, there's no intention in the 2019 amendments to wholesale revise 29A. What we're trying to do is add 6 months to it, frankly, aren't we? Now, whether the detail of the drafting quite does that cleanly enough, we'll find out. But does anyone have any experiences they'd like to give about operating under the 2015 amendments? Could we get a microphone to the gentleman there, please?
I'm coming from Ahmedabad, and speaking only of the Ahmedabad arbitrations, our experience was positive. It had introduced a certain discipline. An arbitration bar started developing, and instead of confining ourselves to only Saturday, Sunday arbitrations, we started working from Monday to Friday during the court hours, and the things began to improve. And whenever we had difficulties, the High Court was sympathetic, and usually extensions were granted. But they were granted with conditions that no more extensions may be granted. So it also gave a message to the tribunal that this is the last time that this request would be entertained. So in quite a few matters, we succeeded in concluding the arbitrations.
Okay, thank you. And before you sit down, could I ask, was your experience that it was the same arbitrators who were able to shift their mindset and their approach, or was it new arbitrators coming in and old arbitrators deciding they couldn't operate under the time-bound system and leaving?
The same pool of arbitrators, most of them are the retired judges of the High Court or the retired judges of the Supreme Court who have settled in Ahmedabad. The same people, the same lawyers, the same arbitrators, but the things began to improve.
Okay, thank you. Well, there's the Ahmedabad experience. Anybody like to offer any experience from other courts? Yes, in the back left there. Is that Raj?
Yeah, I think the timelines that stood in the 15 amendments have worked very positively, specifically in Bombay, cities like Bombay, where we've seen that smaller arbitrations and ad hoc arbitrations are getting over within the 12 months period, maximum to a 16 months period. So I think that's really working. And the other thing that has also helped with this timeline is that we've got new pool of arbitrators. We've seen younger arbitrators, other than the retired judges, counsels who have come in as arbitrators. That's also increased the availability of the arbitrators and their time to complete the arbitration within the time frame provided.
Thank you. Good. Well, unless there's any other comments. So there we go. So the lever of a statutory time limit does seem to have had some positive effect under the 2015 amendment. So let's now turn to the 2019 amendments, and let me ask the panel and see who wants to go first on this. What do we think of the way the 2019 amendments have adjusted the 2015 amendments? Poornima, do you want to take first crack?
Yes, thank you, Nick. I just want to also set some context. I mean, we're a country where our judicial system is much maligned because of the delay. So, you have to place that in contrast to an arbitration system, which now is telling you that you can actually resolve a dispute within 12 months, irrespective of the size of the dispute or the nature of the dispute. I'm not even getting into sophisticated analysis of, do you need a sole arbitrator, do you need expert witnesses? So any dispute, at least in Bangalore, which is my home jurisdiction, and you go to the city civil court, it can easily run to 5 to 6 years with no party wanting to drag it on, right? So contrast that system, and we've heard horror stories of people being in litigation for 30 years or so. So here was a ray of hope, and I truly believe it was working. We've had retired Supreme Court judges who were refusing appointment orders, requests, because they were saying we're too busy, which never happened prior to 2015 because they would still take it on. And the moment the 2019 amendments have come in, we've had at least 2 arbitrations which have now sort of relaxed They were on top speed, they were running well, they were working with the same pool of arbitrators. And so in some sense, it was truly working. And I think it's important to place that in the context of the otherwise sort of slowly churning wheels of the judiciary. I also want to make the point that Justice Patel, in his address last night at the MCIA dinner, said, you have to carry with the system every kind of arbitration, right? Your cotton merchants dispute, your jute merchants dispute, any shipping disputes. So not just the top elite arbitrations, but your consumer disputes or whatever else. So in that sense, can you ask everybody to run on the same road at the same speed if you're not building the road properly? I mean, he was using that sort of transportation analogy. So I think it is for this panel also to discuss, in some sense, how do we build that system within the legislative framework to sort of make sure we're all moving in contrast to the slowly churning wheels of the judiciary.
Thank you. Thank you. Bobby, you had some comments, I think, on the 2019.
On the section. So, I mean, where should I start? I think there are two timelines to my mind, or three timelines, one of which I'm not very clear. The second, third bits are clearer to me, but again, subject to interpretation. The first timeline says that the statement of claim and defense shall be completed within a period of 6 months from the date of arbitrator, or all the arbitrators, as the case may be, receive notice in writing of their appointment. So the period of 6 months is the period of 6 months for the filing of the statement of claim and defense, is what it says. Now, what is the consequence of not completing this within 6 months is not mentioned in this section. Perhaps it may be referred to then in section 29A, which talks about a period of 12 months for the completion of the proceedings and the delivery of the award. And it talks of not the filing of the statement of claim or defense, but it talks of from the date of completion of pleadings, but it gives the reference to the same section, which is section 23.4. So section 23.4 talks of statement of claim and defense within 6 months. No consequence given as to what happens if it is not done. However, a consequence may be provided if you look at 29, which talks about the time limit within which the award has to be rendered. And that award has to be rendered within 12 months of the completion of pleadings. Now, completion of pleadings, again, is not a defined term. Now, if I assume for the time being that this 6 months means the statement of claim and defense, and I will also assume for the time being that this also includes a counterclaim and a reply to the counterclaim, which means all of this needs to be completed within 6 months. Question is, if it is completed within 3 months, then is the pleadings complete in 3 months, and therefore the 12-month period will then run from the 3-month period and not from the 6-month period? Or is it that it will always run from the 6-month period because that is the maximum time given and you can't be punished for being efficient?
My question is reverse. If it is done in 6 months,
yes,
fine.
I was just coming to that.
But if it is done in 10 months,
just coming to that.
That's something where
just the second interpretation, the second part, that if you follow section 23, which actually gives the arbitrators the power to amend, take subsequent statements on record, which could technically be after 6 months. And therefore, that 6-month period which is given in 23.4 is not the mandatory period and therefore can be extended. However, is it that for the delivery of the award, you will limit yourself to the 6-month period from the date of constitution of the tribunal and count the 12 months from there, irrespective whether the pleadings themselves by way of either amendments, etc., were completed or discoveries, etc., were completed post the 6-month period? I mean, that debate is on, but at the end of the day, these provisions, we had almost settled down with the 2015 amendments. We had come to terms with them over the past 4 years. This opens a new Pandora's box, and it opens a new avenue of when and how this calculation of 12 months will take place, and this is again going to be subject to some kind of litigation, whether completed in 3 months is 12 plus 3, or is it 6 plus 3 when it is 8 months or 6 months. The second aspect is with regard to the fact that an application that needs to be filed for an extension of time, now that is to be filed under section 23.5. Now 23.5, or it's 29.5. It says that the extension may be granted only for sufficient cause or on such terms and conditions as may be imposed by the court. So now the scenario is that the moment you move this application, the mandate of the arbitrator does not terminate. And it says that the mandate of the arbitrator will continue till the disposal of the said application. Meaning thereby, when you move an application saying that the extension should not be granted and you show sufficient cause or other reasons why the court should not be granted, and while the court is grappling with that problem, the arbitral tribunal proceeds and delivers an award, does that application become infructuous? Or is it that the application remains alive, and if an order is passed saying that the extension should not be granted, therefore the award will need to be set aside and re-agitated before another arbitral tribunal? So that question is again, I mean, still not sure as to what the answer is. Perhaps the intention was keep the arbitration proceeding going, let the application remain pending if there are important issues which are isn't there, in the hope that the arbitral tribunal will pass an award. Once that award is passed, the application will become infructuous, and then we'll go into the award stage. So
Yeah.
I mean, it's...
There are some questions. Rajbeer, yes,
I
please.
will just add to this. See, the proposed amendment, the Section 5, subclause 4, they have inserted in Section 23. It is saying the statement of claim and defense under this section shall be completed within a period of 6 months. So mandatory aspect is already being built in, shall be completed within 6 months. So there is no scope of extension unless there is some way you go to the court and ask for an extension. It is sacrosanct. According to me, statement of claim and defense will require to be filed within 6 months, and thereafter the 12 months period starts. So yes, you are right in one way. If the statement of claim or defense or counterclaims are filed earlier than 6 months, then 12 months will be reckoned from that day, the day the pleadings are complete. I think to that end, I agree with you. On the second aspect, and this I think I raised it in the first, in my first session, the proviso now being added by the amendment, when application is made and is pending, the mandate of arbitrator shall continue till disposal of the application. Now, that's an interesting question. If the mandate continues and arbitrator, notwithstanding the fact, even if the order is not passed by the High Court, extending the date for the completion of the arbitration proceedings, and he passes an award, whether the award will be a nullity or that award will be enforceable, that's a gray area under the amendment.
Yes, Naresh.
So, Nick, without getting into the issues that the two gentlemen have spoken about, and I have one comment on the time limit. Obviously, the time limit as it now stands goes away for an international commercial arbitration. It remains for the domestic arbitration, which is exactly the French scenario, as you rightly mentioned. My question is something else, and on the lighter side, we can call it discriminatory, because you're discriminating between domestic and international, and on the other hand, one can always argue against it to say you're talking of two different class of people. Therefore, as we understand under our constitution, Article 14 discrimination point will not apply. But on a serious note, the question is this, that in an international commercial arbitration which is ad hoc, seated in India, why should there not be a time limit as it is for a domestic arbitration? Why discriminate between the two? Because ad hoc arbitration could be run by the same set of arbitrators with the same mindset. So why make that distinction? And I understand where this actually comes from. It's possibly, we all know that it was the institutions which were actually pushing for the time limit to be relaxed, removed, whatever. This has possibly been done for the institutions. At best, what could have been done is that you could have relaxed the time limit or taken away the time limit for an institution-run arbitration, because the idea is that the institution is going to monitor it very strictly. There are various sanctions which are put in by the institutions, and therefore the time limit is not required in an institution-run arbitration, and in an ad hoc, on the other hand, you need the time limit. I can understand that distinction, but I can't understand the distinction when you have made it for international vis-a-vis domestic when both are seated in India.
Yeah, thank you. One of my questions too. I mean, for those of you who were here for the rather good opening address by Justice Malhotra earlier, she said that part of the thinking was, well, for international commercial arbitrations, they're institutional, so we'll let the institutions take care of that. But as Naresh says, you also have international commercial arbitrations under the 96 Act, which are ad hoc and seated here in India. So look, lots of interesting questions on the actual effects of these 2019 amendments, and think of those for the questions in a moment, and you can put them to our expert panel here who will give you their current answer. But I want to take it back and go back to you, Shuva, about standing back here. We've amended the Act again in 2019. The intention, I think, is clear as regards timelines. The previous 2015 timelines were too strict. Let's relax them a little bit. Let's tie it to the close of pleadings. Whether that really means the receipt of the first defence, who knows? Let's tie those first close of pleadings, but we'll keep a timeline there. Shuva, do you think, or have you had the time yet to gauge from the perspective of your organisation whether these changes are going to make onshore arbitration in India more or less attractive to your organisation? Are you comforted by the intent and by the changes that have been made? Does it create worries for you? Are you going to be looking more to Singapore, London, please, anywhere else? What's your view?
No, so I think, yeah, thanks, Nick. I think the directional point is correct, that there needs to be speed to resolution of disputes through arbitration. There's no doubt about that. I think there are I think beyond these 12 and 6-month issues, there's a larger issue what plagues delays. I think many of us have touched on this, starting from nature of arbitrators, too much of judicial mindset. I've said it in a prior Mcia conference when Chief Justice Mishra was here. We have to get out of this hangover of retired, nothing against retired judges, but it's ex-judiciary. That is not what arbitration is all about. That's a big hangover. And then the way the procedure is conducted, if you really see, I mean, the question needs to be asked, do we really need oral hearings? I mean, I think the right point was made by Justice Patel that we need to see a system that works for the entire spectrum of arbitrations. So there could be monetary thresholds where we don't need actually oral hearings. We don't need to present tomes of judicial precedents. Some of the issues are fairly well settled. If you see the most, I mean, I don't know, my experience has been off late, even issues like framing of issues are getting contentious. I mean, it was pretty unheard of earlier. So I feel somewhere, again, that's why I'm repeating, I kind of say, there's a mindset issue here. I mean, I think, I know there are many lawyers here, but somewhere there's too much of a legal hangover to arbitrations, which is really not how arbitrations are supposed to be. It is about resolution, it is about settlement, it's not adversarial, it's not about throwing, a legal, technical spin on a proviso to a third section. I don't think that is what an arbitration is, unless I'm, that is adversarial approach to the whole thing. That is not how the act is meant to be. So
yes, Bobby.
I'll take that point, Bobby. But so I think Poornima touched about electronic evidence and just e-filings. I mean, it's like, how do you cut short this conference? You put a 5-minute time, right? That is what we need to do to arbitrations. I mean, there's repetitive arguments. I mean, we recently had an experience where the respondent did not appear for the arbitration, just refused to even appear, no problem. The arbitrator must have spent an inordinate 2 days, 16 hours, trying to convince the claimant what are the rules of service that you've done to serve these papers. I mean, this is what I think is getting frustrating. So when you come to the question, is there fatigue amongst corporate clients, you may say, there is a lot of fatigue. I've said this before, absent correcting speed in the litigation system, you're actually exporting the entire litigation system out of India. So if the conference is about arbitration in India, this discussion is just not going in the amendment is not going in the right direction.
Okay.
When you put even issues like whether an Indian advocate can be an arbitrator. You know, you've got a Schedule 8 issue there. So I think delay being one of the reasons, but directionally we are trying to solve it, but I can also tell you directionally, clients are exporting themselves out of India on the litigation.
Okay, that's a clear but not necessarily encouraging message. Thank you, though, Shuva, for giving us unvarnished insight there. I'm going to turn to Bobby, and then I'm going to ask if there are any more questions in the room. Bobby, you wanted, I think, to respond to Shuva.
I think Shuva made a very pertinent comment on whether we should be having oral evidence at all. Now, I can just share my experience with you as a lawyer.
Oral arguments, actually.
Pardon?
Even oral submissions.
Even oral submissions, correct. Even oral arguments. Closing arguments can be in the form of a written submission, and certainly, I mean, I take that point. The problem, I mean, I don't have a problem with the closing arguments being in the written memorial style. The problem with regard to the oral evidence part, what I feel as a practicing lawyer, is what happens when I have a damages claim, which I have not led by way of evidence, but by way of my statement. And when it comes before the court, because I've been through that scenario where parties agreed not to have a cross-examination, and the court said that, listen, this was a damages part. If you don't have a cross-examination, how can I agree to what the damages part are? And therefore, set aside that part of the award. Now, when you hear judges like that, now I'm not saying that he was trained particularly in how arbitrations are held, but at the back of your mind, you have this thing that, listen, at the end of the day, if you have to go before that judge, then you better be sure that you have ticked all the boxes before you actually go before him. So sometimes it's not about us. We also have to think about the client when we actually give up our right to cross-examine.
So how do you look at it? Are you looking at arbitration as arbitration, or is it a private judicial process? I mean, what I'm hearing more and more is directionally we're looking at it as a private judicial process.
No, Shuva, the issue here is
Bobby,
that
I'm going to interrupt. I'm going to cut off that question because it's very provocative and it could take us a long time to answer. I'm going to just cast around before we run out of time and check whether any more questions or comments from the floor that you would like to put to the panel or indeed the room. No, we seem to be good. In that case, Bobby, I'm going to give you 90 seconds to answer Shuva's question and then ask for any further thoughts from the panel just to wrap up. I think Shuva is basically contending that we should kick the lawyers out of the arbitration, make it a less lawyer-led process, and that could be the solution. Now, I'll take a show of hands on that in a moment, and we'll see who wants to vote for Christmas. But that, I think, is a punchy message takeaway. Clearly, there's more that we need to do as all stakeholders to make arbitration work better, because if our clients are saying that they are skeptical of the process, and somewhat concerned that even though the heart may be in the right place on these amendments, they're not taking it where it needs to go to be useful for users of arbitration, then clearly we have more to do. But let's go back to the very first comments that were made on this panel, that we need to think about mindset as much as structure and as much as incentives. We need to think about mindset, about how we make this work in all of our interests and in India's interests, and frankly in the wider cross-border economy's interests. With that, I'm going to wrap up. Thank you very much for your patience. We've probably got a break and then we've got the debate afterwards. But thank you very much, and please thank the panel for this most interesting discussion.